Yes. Good
Am I-
afternoon. Am I audible?
Yes, sir.
Please introduce yourself without mentioning your name.
Sure, sir. I earned my LLB in December 2023 after completing my chartered accountancy, company secretary, and intermediate cost accountancy in year 2012 and BCom in 2009. I ranked 12th in Odisha in the intermediate examination and received certificate of merit. Uh, Post that, I worked with KPMG as an executive and later as a partner and proprietor of a CA firm. Currently, as an advocate, I have experience in drafting commercial contract and advisory services. Outside of work, I love doing cooking and journaling.
Okay. Uh, do you think that you'd face some language barrier here in Odisha, working in Odisha?
No, sir, I know Odia as well. Read, write, both I know, sir.
Okay. And if I may be permitted to ask, why this switch in the career at this late juncture?
So, a major health crisis in 2000 made me realize how fragile life is. Despite professional success, I felt unfulfilled. That difficult phase pushed me to look beyond professional success and seek higher purpose in life. Uh, and inspired with Vivekananda's word, service to mankind is service to God. I find judiciary as a platform, as a means to serve the society. This second chance of life is not just a gift, but a chance to rise to serve to this society through judiciary as a cause.
Okay. Don't you think you can serve the society by practicing? You could do very well there. With your experience, probably you would be unstoppable in the field of
Yes,
practice.
sir, in a practice, we are supposed to look after the interest of the client and do all the things which are required for the interest of the client. And judiciary represent the society, wherein we are doing the justice for the society and not only for one individual interest.
Let me give you an example. Tell me who can serve the society better here. Okay. Suppose a person has been charged with theft. The reason being he was stealing a piece of bread for his family who is dying out of hunger for the last 3 4 days. Nobody has eaten anything. He's trying to steal a piece of bread and he barged into a house. He was caught there and he was forwarded. Now he's being tried. As a judge, you are supposed to only hear the evidence, apply the law, and if evidences are going against him, then you are supposed to convict him. But as an advocate, you can probably defend his case and you can probably serve the society better. What do you think? What is your view on this?
Sir, it is a trivial offense, and though the intention has to be looked by the judiciary and not the motive, that's the purpose is to meet the hunger. Intention is immediate is the theft, but it's a trivial offense wherein only the theft is of bread. So in IPC, the trivial offense are not punished.
No, what if it is a box of bread, like which is costing around 1500 rupees? Entire box of bread he has stolen. Then it's not a trivial offense anymore. The shopkeeper wants to prosecute him. What about that then?
So this has been addressed by PNSS, wherein the PT offences, the now magistrate have power to give community care service as a punishment, and which is not be available as an advocate to me, and I would be charging fees might be with the as in practice as an advocate, I would be also become like any other advocate. There will be a threat to my profession, and but in judiciary I have an impartial nature, and that is something which I will not get as an advocate. And I can also, instead of punishing him with an imprisonment or fine, I will punish him with community service.
Okay. What are the key features of the central budget that was presented recently?
Sir, the important is the lower middle class till 12 lakhs there is no payment of tax is required, though the slab is there, but 87 rebate is provided wherein till 12 lakhs they are not required to pay tax. And MSME, there are a lot of advantage given to the MSME who are small scale industries to further because in India the government is more focusing on making it as a manufacturing unit and empowering the small industries to become large. So this is also one, and the for women's there are a lot of scheme has been provided, and in the Odisha government also providing one scheme wherein the government is giving 10 lakh rupees of interest free loan to women's to have this small scale unit. And
Can you tell me the names of the states with which Odisha shares its boundaries?
sure, sir, Visakhapatnam, Jharkhand, uh,
Visakhapatnam, is it a state?
no, sir, Andhra Pradesh,
Yes.
Jharkhand, and Chhattisgarh. So this is I recall.
West Bengal?
Uh, Sir, slightly it is. I think so. I'm not sure.
Suppose you are sitting as a civil judge, there is a plaintiff who is bringing an unregistered suit and saying that this defendant has sold this land to me. Now the bringing the record of rights, that is the ROR, and saying that see sir, see madam, this land still records in my name. Now, what will you prefer within these two? Unregistered sale deed or ROR?
Sir, as per Section 54 of TPA, for sale, it must be to be done through registered sale deed, and the name in the mutation document or ROR is not the final proof of the ownership. It can be after the actual transfer of a transfer through sale, the name can be replaced through mutation. So, agreement to sell is not a valid proof of document. Considering this case, I will consider the ROR until the real owner dispute this scenario.
An offence took place on 30th June of 2024, just before the new laws came into force. And the FIR was lodged on 1st of July 2024, just after the laws came into force. Tell me, under which sections of IPC or BNS which will be followed while registering the FIR, and what procedures will be followed while carrying out the investigation, CRPC or BNSS or BSA or in Evidence Act. Tell
Sir,
me, both substantive and procedural, what laws to be followed?
yes, sir. Article 21, 20, subsection 1 of the Constitution says that the law which is prevalent at the time of commission of crime, that will be the law. So here, the IPC will be seen for the for charge framing charge, but the procedure will be followed as per the BNSS, because BNSS the procedural laws are retrospective laws. And it is also cleared by the guideline by the court.
So the CRPC law will be followed.
The BNSS will be followed, procedural law, and IPC for framing.
Okay. Okay. Can a revision be made against an interlocutory order?
Sir, can you please repeat the question?
Can a revision be filed against an interlocutory order?
Sir, if there is any procedural defect or the interlocutory order or interim order, which is not based on the merit of the case, and immediate relief is given through the interlocutory order. But if it is violating any provision of law like jurisdiction or any other, then revision appeal can be filed.
What is preemption?
Sorry, sir, I'm unable to recall now. I knew the answer, but unable to recall now. I'll definitely look into it.
No issues. What is a lame duck session? There is a term called lame duck session. Can you tell me what is it?
No, sir. Sorry, sir. I think that it is for the dumb and deaf witness, but I'm not sure about it.
No, it relates to constitution. Can you tell me?
No, sir. Sorry, sir. I'm not aware of.
Okay. Can, can you explain me the concept of transit anticipatory bail?
So it is given in the Atul Subhas case recently in news. The anticipatory bill, transit anticipatory bill is when there is an anticipation of arrest, then accused who is anticipating that the arrest will happen, apply to the court, high court or session court for the anticipatory bill, and this is only for the duration of transit and not lasting till the end of the trial. So usually the anticipatory bail is for the entire period of the trial, but the duration has been shortened through transit anticipatory.
What is a hundi?
Sir, it is a traditional negotiable instrument. However, this term is not present in Section 13 of the NI Act, which does not recognize as a negotiable instrument.
Traditional, but what happens there? Tell me. What is the procedure?
Sir, if suppose a person has to pay a certain amount to somebody, then instead of paying the in future date, then for that he will give a hundi wherein he promised that he will pay on certain date, and this is transferable like any other negotiable instrument. Endorsement is possible, and the person who is holding it as a bearer can recover that amount on the right date by presenting that hundi.
There is a couple, and now they have been separated. There is a divorce. Now the girl is alleging that this child is the child of this particular person, okay, of the husband. But the husband says, I had no access to her, and he is in fact insisting on a DNA proof. Now tell me, between the presumption that is laid down in VSA or IEA and DNA proof, which one will prevail?
Sir, in the latest judgment and one of the case, Nandlal Bandwidth versus Lata Bandwidth, their Supreme Court has mentioned that this interpretation has been cleared by saying that in case of legal presumption and the scientific proof, the scientific proof will prevail. However, Section 112, the conclusive presumption is on legitimacy, and DNA is giving the paternity test, not on the legitimacy. So, if the child is born during the period of marriage or after within 20 days after the divorce, then legitimacy is with the father, with the husband, and the husband will be called as a father of the child.
Even
And
though there is no paternity.
sir, I understood that, but yes, sir. Because the paternity is disputed through DNA, but legitimacy still remain because the child interest would be seen paramount importance, and he should not be illegitimate.
Okay. What is the main purpose of a case diary?
So the main purpose of the case diary is to see is the magistrate see that all the procedures prescribed to the police officer has been followed, and in case there is any kind of discrepancies in the proceeding, he referred to the case diary. And in case the police officer is saying something else what is mentioned in the case diary, then he can also refer that case diary to the police officer. In that scenario, though the case diary is not to be seen by the as a right by the accused, but when it is referred by the magistrate while opposing what IO is saying, then the case diary may be given to the accused as well.
Can a magistrate cancel a bail?
Yes, sir. The cancellation, the threshold to cancel the bail is higher. It is also given. It is also mentioned in Union versus Sanjay Gandhi case, and the cancellation is only done by the court of session and higher court. And the ground for cancellation may be like there is a risk of tampering evidence. He might be not available for investigation and flee from the country, and there is threat to the life of the witness, and so on. There is no hard and fast exhaustive conditions prescribed. It has to be seen on fact and circumstances of the case.
An agreement in restraint of trade is void. Is there any exceptions to this rule?
Yes, sir. Sir, in monopoly cases wherein it is for the purpose of the society, there's many cases. One is your monopoly cases where the that government is having that monopoly, like railways, nuclear energy release. Therein, it is a restraint of trade. That the state itself is saying that they cannot enter. So this is still a valid and something for the like one society is having one state is having evidence of provisionally consumable, but the other state is not having that consumable, and they want to trade. An agreement to restrict such is not prohibited, but agreement to permit that is permitted.
What is doctrine of Cyprus?
Sir, it is provided in the TPA Act, wherein condition precedent to fulfill for transfer of movable property is seen as a light. Where the if the condition are very stringent, then the substantial part of it is fulfilled. Then still the transfer will be allowed. The law generally prefer the transfer instead of accumulation. So, sir, may I give illustration to it? If the ABC, if permission ABC is required to transfer a movable property and C died during the before the transfer, then the only permission of A and B is allowed. And even if the C is not given permission because of his death, then also it is valid transfer.
What is horizontal reservation?
Sir, there is a statutory limit to the reservations provided. So if more than 50% is not allowed. So, but if in the case wherein the previous reservation seat has not been filled, then subsequently in the next vacancy, uh, what has not been filled by the previous vacancy, that is added with the 50%. The threshold is increased by 50%, but it's still allowed under the horizontal reservation.
Suppose a person wants to sue as an indigent person, and for the same, he makes an application in a court. He pursues it for some time, then decides that probably he will not win the case. That's why he will not probably succeed in the application. That's why he withdraws the application. Now he wants to sue as a normal person. But there has been some time elapsed already, maybe 4 years, and it's a money suit, so limitation is perhaps over if you calculate those periods during which he was prosecuting as an indigent person. An application to sue as an indigent person, what he was prosecuting, during that the time is over. Should we give him time That means whether he would still be exempted from limitation. What is the position? Tell me. He withdraws voluntarily.
Sir, so at the time of filing the indigent application for indigent suit, he has fulfilled the criteria that he is an indigent. And he has applied for to file a suit without court fees as an indigent, but the case is still going on, and he has not won that matter. And so that in this scenario, the date from the limitation will be period will be till the application of the date, and not will be from that when the subsequent petition has been filed as a regular person. So he will be given the advantage.
Have you gone through this? Please go through it again, okay? What is the position when he withdraws? Please go through this again, okay? Uh, Tell me, police suppose fixes a voice recorder in the vehicle of an accused and records a conversation and wants to use it. Can he use it?
Sir, this conversation is relevant but not admissible, and this has been mentioned by the court in Puspa Varma case and Rikisto case, wherein evidence may be collected through the means which are not permissible. But if it is if it is too much illegal, if it is too illegal and breach the right of the privacy and those of the accused, then in that case it is not admissible. But still, this evidence is has been given by the court.
In the Arjikar medical case recently, the name of the victim was revealed in media. Is there a punishment or is there any provision prohibiting all of this?
Yes, sir. In section 228 of IPC, the victim names should not be published or not been mentioned in any of the proceeding of the court, and it is punishable.
Then why no steps were taken? Include Dhruv Rathi, I think, revealed her name in the YouTube post. He is a famous YouTuber. So many subscribers are there. Nothing was done. Why is it so?
So it is on the discretion of the court. The court can either punish with imprisonment or fine or both, or may give the warning, and the punishment power to decide is with the court, sir. However, this is punishable under IPC 228A section.
Why independence of judiciary is very important? Tell me.
Sir, judiciary is third pillar of our constitution, one of the pillar of our constitution, and in India we follow the separation of power between the judiciary, legislative, and executive. And being independent, if judiciary is not independent, then the right of the fundamental right and other constitutional right of the citizens are in danger, and there will be a chances that the legislative and the executive will be the whims and fancies and desires of the legislatures will be imposed uh, upon the citizens, and we consider constitution as supreme and not the king. We don't follow the parliament as a supreme rather than a constitution is a supreme. So parliament is subject to constitution, and judiciary is guardian of the constitution. So in upholding the rights which are there with the citizen, the independence of judiciary is very much important, and it is one of the basic structure.
You said judiciary is the third pillar of the constitution. Can you tell me who is the fourth pillar?
Sir, media.
No, that's not true.
Print.
Media is not. Can you tell me? There is a functionary, constitutional functionary, which is. Media is not a constitutional functionary. It's Comptroller and Auditor General of India. Okay, who is the guardian of the public purse? Because you were related to cost accounting and CS, that's the reason I asked. Okay, can you tell me uh, any ways how we can address the issues that we face in delay of civil litigation? Because in India, there was a survey which says that the average age of a civil suit is more than 10 years. So, can you tell me certain ways in which it can be addressed? This issue can be addressed.
Sir, speedy trial is the mechanism through which we can reduce it. And now in the Indian Evidence Act, in order to speed up the trial, the witness and the victims and the accused are allowed to hearing be through electronic and video means, and even the affidavits are also allowed, wherein the witness are stating their statement through affidavit.
That's all. Nothing as such. What about adjournments, other issues?
Yes, sir. So adjournments, sir, without any sufficient cause, adjournments is not to be given. Like in the BNSS, they have mentioned that after two adjournments, it is not permitted. So similarly, in the CPC, it's not mentioned, but it should be restricted as far as possible.
Now, in a recent case where there was a Porsche murder case, Porsche accident, wherein the a boy was driving and he killed certain people because of the rash driving. He was below 18 and he was granted bail by juvenile court. Okay, the rule is very clear that in the case of juveniles, bail is the rule. So if you don't give him bail, then you have to justify why you bail was not granted, no matter what the offense is. So the judge was perhaps right in granting him bail, but still he was questioned in media. He was shamed as if he did not know law and all of that. My question is how a judge should handle media scrutiny, because sometimes it might happen that you will do your job properly, and for doing your job properly you will be questioned, because these lame people, they don't understand that the law says that you have to give bail to a juvenile, whatever offense it might be, and they question you. So how a judge should handle the media scrutiny?
So this media trial is first, this nomenclature first come in KM Nanavati versus State of Maharashtra case, and the first and foremost quality of a judge being is impartial and neutral, and he should not be subjected. His decision should not be subjected to the pressure of the social media or any other kind of discussions happening around the world. He should hold the fair trial should be held, and as per the law, the rule of law should prevail, and not the current scenario and the opinions of the society. And in this case, the court should have to strictly follow what is there in the rule of law, and not with the media trial, and that has been reiterated by many of the judgment, even by the apex court in Sahara case, Sahara Real Estate Corporation case, and many other cases wherein the even guideline is also prescribed by the apex court. Two three guideline is one is like, whatever the proceeding is happening in the judiciary, that should not be printed by the media in in biased manner or exaggerated manner. The witness in the current BNSS also, certain guideline is there, like witness should is allowed with guardian, and there will be separate place wherein witness safety will be taken care, so there's media trial and the other kind of violence which happen, that will not influence to the judiciary. Current scenario of the current social media and internet prevalence and the access to it is giving threat to the judiciary on that, and this is what the judiciary has to be more impartial handling the cases in front of them, and for that the guideline is also prescribed by the apex court.
Okay, thank you, madam. That will be your interview, and let's move to your feedback now. Okay. Madam, I have three things to point out. Yes, you are a very good candidate, and the panel would be very pleased pleased with your interview. And if I was the final interview, then I would be pleased. So some points I would say. One is when I gave you the option of choosing between advocacy and the profession of a judge. You taking one side is different, but you can't take side at the cost of demeaning the other side. Are you getting it? So you almost demeaned advocacy as a profession. And let me remind you, the judge who would be interviewing you, he must be an advocate for some length of years, and then only he would have been elevated to High Court judge. So he would take it personally, mind you, madam. You literally said that advocates are probably they can be sold off, they will take money and they will just belong to money. You can't say this.
So,
Okay. So no. I mean, from lower judiciary, hardly anyone reaches High Court. Only from those bar, only after practicing over 20 years, 30 years, they reach High Court. So the struggles that I have seen, if you just dismiss them, then it will be very problematic. So don't do that. Anywhere, if you are given an option to choose it between two, you say that yes, the other one is better, but I prefer this one. Okay, so you when I was giving you this option, you could have said, of course, sir, as an advocate also I can contribute meaningfully to the society. I can fight people's cause, fight poor people's cause, but I see myself fitting into this role better. So okay, so it should be that my perspective is this, not that that option is bad. Okay, this thing you have to make it clear at the outset. Any option that you are given, whenever you are countered with two options, you always say the other option is also good, but my choice is this, and my inclination is towards this. That way, you will not hurt anyone. Clear?
yes.
One more thing is introduction again. The merit part you could have probably skipped. You shortened it as per my last interaction. You have shortened it, but the certificate of merit, all of this was not needed. Okay, 12th rank. That's all.
Okay.
Maybe or a CM awardee. Simply two words. You can't elongate it that much. Other than that, the introduction part was good, and I have no problem with the way you answered the questions as such. You could answer well. You are maintaining a very calm pace throughout the interview. It's a very calm interview. The atmosphere is calm. Probably, if you can smile a bit more, not be too serious, that will be also okay. Okay, not like laugh or anything, but just to make it more pleasant, it is you can be doing that. Okay. Other than that, I see that you are interactive enough. You respond to the questions well. You are maintaining eye contact. The panel would be sufficiently pleased in your mannerism. Okay. So I have no problems as such. If you have any questions, you tell me.
Sir, suppose if the panel is, if I have given an answer and they want to say that no, this is not the correct one, if this is the scenario, or they are pushing it hard that whatever I'm saying, I should change my opinion.
Uh, I mean, if they're exactly saying that no, you are wrong, this is the correct thing, then maybe I beg your pardon, son. I was mistaken. I was under a mistaken belief or something of that sort. You should agree. You should agree to that.
So,
If they're, but if they're saying, if they're pushing it to test your
yes,
knowledge, test your deepness, then you don't change it. So you have to first ensure yourself that whether they are saying that no, this is wrong, and this is the correct answer, then you agree. But if they are saying, are you sure? Then as such you don't change it. Okay. As far as I can recall, this is the correct view. Okay, now let them make a suggestion, make a change, and if they keep on persisting, and then you will of course feel that this is the correct answer perhaps, and then you are better to agree instead of being dismissive of their answer. Better to say maybe I was under a mistaken belief, something of that sort you may say.
uh,
Okay.
so like affidavit, change of affidavit,
Hmm.
change of amendment to pleading is allowed under 17, order 6, rule 17,
Hmm.
but affidavit change is not allowed.
No.
So yes, sir. And then amendment to amendment application is also allowed because nothing is mentioned there. If I'm
Yes.
mentioning that, so there is nothing is mentioned it. So they are trying me to say, to change my answer by giving another and another statement with regard to the law. In that,
Yes.
I can say, sir, I think still that this is the answer.
Yes. In that way, you can say. But if they're actually dismissing your answer and saying that this is the correct position, then better to agree with it.
Okay, sir.
Even if you think that it's not the correct position, it's better to agree with it. There will be situations when, in fact, there are situations like inherent power. A lot of people think that magistrates do not have any inherent power. My view is that magistrates have inherent power. It says that the High Court's inherent power is not limited by CRPC. Never it says that magistrates do not have inherent power. In fact, if you see the old 1898, then magistrates also have inherent power. Okay, that is the inherent power is not given anywhere. Inherent power means it is a power of the court which is inherent in itself. Because it's a court, that's why it has certain power. That's called inherent power. It doesn't have to be given by statute. But high courts, for time and again, they have misunderstood. So that there are times probably the panel would say something else. They would say, no, no, only high courts have inherent power. So in that case, you may agree with it, even though you don't really support it. I'm just giving you an example.
Yes,
Okay,
sir. So answer are short and crisp, or it should be further shortened.
this is okay. This is okay. 1 2 questions you elaborated a bit too much, like media scrutiny. I mean, but those are questions which where it is opinion based. So maybe you are allowed to elaborate a bit. That is okay. Okay, opinion based question you can make it a paragraph or like 10 5 10 lines you can make. Other than that, if there is strictly answer based, then as I told you previously, stick to the answer only. Okay.
Okay, sir. Thank you, sir. Thank you very much.
Thank you, madam, and all the very best. I hope to see you soon on the other side. Okay.
Thank you, sir. Thank you for your
Thank
time.
you. Thank you.